Good morning, everyone. Thanks very much for joining us. My name is Charles Livingston. I am a partner in the Government Regulation and Competition team at Brodie's LLP. I'd like to welcome you to this morning's debate on the United Nations Convention on the Rights of the Child, specifically the bill that incorporates that into Scots law, and very pleased to be joined by six young people who are obviously one of the key focuses of the legislation, and hope to have a very interesting debate for you this morning. This is the last in a series of webinars we've been running on the UNCRC Incorporation Scotland bill. Towards the end, we'll come back to a little bit more detail on the previous sessions we've run. So if you want to know more about some of the legals, some of the technicalities, and some of the policy around the bill after today's debate, and you haven't already seen those sessions, you will be able to come back to them. But our debate this morning, our proposition is that this House believes that the UNCRC bill will create more work for lawyers than benefits for children. So that is the motion. We have allocated our six speakers. We've split them between for and against. So just in case you were wondering, they have not necessarily volunteered for their position based on their own individual view. That's often what makes a debate challenging. And you'll probably see from some of their biographies that even some of the people arguing for the proposition probably don't believe it. But what we are looking to do in order to essentially judge the winner, to the extent it's competitive, we're going to start with a poll. So we're going to put up a poll at the start and at the end, and essentially the name of the game for the two sides is to try and move opinion in their direction. So largely regardless of who has the majority opinion, they're looking to move. So I'd be grateful if everybody in the audience could vote. So the question, do you believe that the UNCRC bill will create more work for lawyers than benefits for children? Yes, no, or you are undecided and just looking to be persuaded by our speakers today. Okay, so there we go. So you've got an uphill battle, those of you who are arguing for the proposition, but you might also view it as a target-rich environment. There are plenty of people to move in your direction, whereas if you're arguing against the position, you have the wind at your back, but there are not as many people to persuade. So we have 20, 60, 20, and we'll see where those end up at the end. Okay, so if we take that poll down, we'll move on to the rules of this morning's debate. So each of our speakers will have 5 minutes to present their arguments. We will have opening speakers for and against the proposition, then our middle speakers, and then our closing speakers. Each team is expected to accept 3 points of information across their 3 speeches. So it's not necessarily that each speaker needs to accept one. If somebody's feeling bold, they can accept more than one. But if the first 2 speakers don't accept any, then the final speaker is going to be fielding 3. So I'll be looking for a bit of teamwork there. The first and last 30 seconds of each 5-minute period, those are protected, so nobody can offer a point of information during those periods. I am obviously chairing the debate, so I will have my timer on. If anyone tries to intervene within those periods, I shall strike them down. If anybody goes past their 5 minutes, I'll come on and tell them that their time is up. But each of our speakers are monitoring their own time. Obviously, it's a little bit more difficult in terms of doing this virtually than if we were all in the same room. But we will see how everybody gets on, and I'm sure everybody will stick to the rules. Okay, so if we move on, then we'll get to our debate, and our opening speakers for and against the proposition. So for, we have Ailey Lynn is our first speaker. from Balfron High School. Ailey's just finished her 6th year at Balfron and is going on to study modern languages at Edinburgh University. She's a member of Amnesty UK's Children's Human Rights Committee, where she campaigns for the protection of child rights. And in 2019, she attended the 30th anniversary of the UNCRC at the United Nations in Geneva. She's interested in child voting rights and how this related to the UNCRC. Then arguing against the proposition is Ewan Davies of George Watson's College in Edinburgh. Ewan is in 5th year and studying hires in English, maths, physics and geography, has a keen interest in politics and participates in Model UN and in his school debating club. He was born in Sydney, Australia and moved to Copenhagen at age 10 before moving to Scotland in July 2020. So just in terms of how we are taking points of information, if everybody who's not the speaker could turn off their cameras, and then if somebody has a point of information to make, turn the camera on, the speaker will see you, and they can then decide whether to take that point of information. Our first speaker is Ailey. Ailey, if you're ready, your 5 minutes start now.
Thank you. Ladies and gentlemen, Mr. Chair, we the proposition defend the motion as the UNCRC bill is in fact not beneficial for children and creates unnecessary work for lawyers. Today, I will be focusing on how we can best support children from a human rights perspective and the most effective way to protect child rights. My partner Libby will focus on financial costs of the bill and the Scottish-English divide, and my partner Cameron will focus on the issue of the Supreme Court challenging the bill and its implications. First of all, I would like to acknowledge that, ladies and gentlemen, Mr. Chair, we want to protect child rights. We want to do what's best for children. And incorporating this bill into law will not be doing what is best for children. The UNCRC is a tool meant for children. Children are supposed to understand it. Children are supposed to be able to utilize it. And incorporating it into law alienates children from the UNCRC. They do not understand this type of legislation. The purpose is to ensure there's a piece of child-specific legislation, but by incorporating it into law, we will be taking away something that is child-specific. We're taking away the fact that right now the UNCRC is accessible, it is easy to understand for children, but we would be overcomplicating a simple human rights document. Yes, please, Ewan.
So you've said that the UNCRC will be more tangible if it isn't introduced into Scottish law, but how is a piece of vague international law more tangible to a young child than a piece of local law?
Thank you. Because if we incorporate it into law, that's the issue. It's the incorporating it into law that is the issue, because it alienates it from children. Instead of focusing on how the law should serve children, we should look at how this bill, the UNCRC can serve children. Instead of spending money on incorporating it into law, we could spend money to ensure that children know which rights they're entitled to. We could spend money to ensure that children know how to claim their rights. The UK government or the Scottish government have not ratified Optional Protocol 3. Optional Protocol 3 and the UNCRC would allow the Committee on the Rights of the Child to hear complaints from individual children who believe their rights have been breached. The committee can only hear these complaints from children if their government has signed up to the process by ratifying Optional Protocol 3. We in Scotland have not signed up for this. The UK has not signed up for this. So children in Scotland cannot complain if they think their rights are being breached. But apart from that, the majority of children don't even know that the UNCRC exists. So to come back to my point, it would be a lot more valuable to spend these resources that we would be spending on incorporating it into law to ensuring that children are educated on what rights they have. They're educated on how to claim those rights in a child-friendly way, that they're educated on that if they think their rights are being breached, they can go and let that be known. This would ensure that instead of alienating children from a document that was created specific to them, that was created to make sure that there is a human rights document that is child specific because children have individual struggles and individual issues. It would ensure that that piece of legislation, that Declaration of Human Rights, is still directly linked to children and that they still have access to it, whereas incorporating it into law will alienate children from it. So I propose that instead of spending resources and money incorporating this bill into law, we spend resources and money educating children on the UNCRC, and we spend resources and money campaigning for the UK or Scottish Government to ratify Optional Protocol 3, which would ensure that children can let people know if they think their rights are being breached, which in my opinion is a lot more valuable than ensuring it's in law. Ladies and gentlemen, Madam, Mr. Chair, we want what is best for children. Incorporating the UNCRC into law is the most beneficial for children. They need education on their rights and knowledge of how to claim those rights. They don't need to be alienated from a human rights document that was made for them. Thank you.
Thank you, Ailey. Excellent timing. I picked up the phrase unnecessary work for lawyers there, which is just an incomprehensible concept to me, but okay. So Ewan, I have restarted my clock. If you're ready, away you go.
Thank you, Mr. Speaker. I have three main points that I wish to raise before this debate, and I will engage in rebuttal of the first speaker's proposition when their points match with mine. I'm going to start by saying the UNCRC is not a new piece of legislation, and to explain this, I'm going to have to go into some detail. The United Nations Convention on the Rights of the Child is a piece of groundbreaking international legislation that was created in 1989, and it contains 54 articles and 3 optional protocols, all of which are aimed at protecting the rights of children. It has been signed by every state on the planet except the United States of America, an extraordinary feat of multilateralism. This means that the rights enshrined in the Scottish UNCRC bill aren't new. They're something that we have already in international law. So instead of introducing new rights, this bill is instead reinforcing these rights within our own law system. And this means there'll be no more work for lawyers, as Britain should already be following this piece of international legislation that they've signed up to and should already be implementing the rights that they have agreed to implement, which means there should be no more work for lawyers. This should just be in reinforcing these rights within law. But if Britain isn't following these rights, there will be work for lawyers. The side opposition will not deny that, and we will instead point out the fact that if Britain or Scotland isn't following the rights implemented in the UNCRC bill internationally, then the benefits created for children by implementing it in Scotland will outweigh the work of lawyers, because we're increasing the benefits for all of the nation's children in exchange for the work of very few lawyers in the government sector. My second point, which I want to point out, is the fact that the actual forces of the government act in the best interests of the children of Scotland. It will prevent the hostile Britain policy adopted by Westminster being applied to immigrant children and their families. It will do this by making it illegal to separate children from their parents, and it will also make it illegal to deny welfare parents to immigrants and their families if it will cause harm to a child, all of which will cause great benefits to children at little extra work for lawyers. Furthermore, it will create a structured approach to education during international crises such as our pandemic. It will force the Scottish Government and local authorities to provide the materials required for children to have a high quality of education, regardless of whether it is something brought forward by the Scottish Government. I'll take your point of information.
Thank you. Do you not think that children could be educated on what rights they're entitled to without incorporating this into law? Because we could use the resources just to educate.
I would strongly disagree with the proposition speaker here. It is important to educate children about their rights, but I would argue, and so will side opposition, that it is more important that children have these rights protected by local Scottish law. Because despite the fact that it is a piece of international legislation is often broken. And by introducing it into Scottish law, where there will be severe legal ramifications if someone breaks or hinders these children's rights, it will be a much more effective mechanism of protecting children's rights in Scotland. I will now move on to my third point. The UNCRC bill, and I quote the Scottish Government here, gives the power to the Children's Commissioner to take legal action in relation to children's rights where necessary. And I think this is a very important point to raise. It will create work for lawyers. if legal action is taken. Opposition will not deny that either. But if legal action needs to be taken by a children's commissioner, then will be a clear breach of children's rights or negligence of children's rights that will demand this legal action. And thus any benefit, any extra work provided for lawyers will also increase the amount of children's benefits available for the children of Scotland. And even if we look at it this way, there are very few lawyers who work in the government sector, whereas there are quite a large number of children in Scotland, several thousand. And yes, the work of a few lawyers might be a lot for them, but in the grand scale of things, the benefits of 50,000 children will always outweigh the work that is provided for a few extra lawyers. And this is where the side opposition disagrees with the proposition. Propositions say that children need to have access to this children's convention, and that they should be able to raise their points with this United Nations if they believe their rights are breached. Would it not be much better to have a local Scottish Children's Commissioner protecting the rights of Scottish children? Because not only will they be able to take legal action on behalf of these children and behalf of those children who cannot understand their rights, don't know their rights, or simply do not have the materials required to address their lack of rights. This instead will bring many more rights to the Scottish children. And that's why I urge all people to vote side opposition. Thank you.
Thank you, Ewan. Okay, food for thought there. Once again, picked out a particular phrase, no more work for lawyers. Equally terrifying is the concept of unnecessary work for lawyers. Okay, so next on to our second speakers. So speaking for the proposition, we have Libby Hunter, who is a fifth-year pupil at Douglas Academy in East Dunbartonshire. She's currently working on her Hires and Advanced Higher Music and will continue at school for 6th year. She's arranged work experience in a law firm and next year plans to apply to study law with Spanish at university. In her free time, she's a keen musician, plays French horn and piano. She also enjoys spending time with her new dachshund puppy. Then speaking against the motion will be Kiva Gibb, who is in 4th year at Holyrood Secondary in the south side of Glasgow. She's just finished her National 5 course, is excited to be continuing on to 6 Hires in August. In her spare time, she enjoys practicing music, reading, hanging out with friends, helping refurbish the local primary grounds, as well as taking clubs for children. She hopes to study Scots law at university and then study law at Yale, specialising in commercial litigation. I think that's more of a plan than even I have at this stage in my life. And not to mention having her own firm and might even show the MSPs in Parliament a thing or two if and when she decides to run for MSP. So if we can start with Libby. Libby, if you're ready, your 5 minutes start now.
Good evening. And thank you to Ailey for starting our team off. Today, I'm going to talk about the underestimation of costs, the extended time limits and the effects that this has on the children, and finally, how certain elements of the bill contradict the devolution settlement. The previous speaker mentioned the benefits for children, and later on in my speech, I'll talk about why I disagree with this. To begin, I'm going to discuss the financial issues that will be apparent with the bill. The Scottish Government has predicted a cost of roughly £2.1 million to implement this bill. However, the Faculty of Advocates have suggested that this is vastly underestimated to implement the bill, but the budget doesn't consider the cost to public authorities, litigation, Scottish Legal Aid and the Children's Commissioner. To implement the Holyrood Bill for UNCRC, it is completely unrealistic to suggest that £2 million will cover all necessary costs. Although the bill should make it easier for children to access the rights, it has failed to consider the significant financial consequences which have been underestimated in the memorandum. For example, the financial strains put immense pressure on the Children's Commissioner and the Scottish legal aid system to succeed and provide the most efficient outcome for children. Yeah.
Thank you. You raised the point of costs, but side opposition struggles to see how this relates to extra work for lawyers or no benefits for children. How is this relevant to the motion?
Well, as I mentioned, the extra cost, it puts a lot of more pressure, as it leaves a tighter budget, and it just causes more stress and pressure. Yeah. My second point is the detrimental effect that this new bill will have on the children. Currently, there's a 3-month trial period for judicial review, which was introduced in 2014's court reform to avoid delays and challenges when a decision was claimed to be unlawful. Regarding children, authorities need to make prompt decisions regarding the care and the education. If this is delayed until a child reaches, say, the age of 18, the issue is becoming academic, and the review of the case have to be passed and be too late for the lawyers to attempt to correct. In another statement from the Faculty of Advocates, they say that obviously the time limits have the discretion to extend, and by extending these trials, it's putting children through unnecessary trauma, which could be more damaging than the actual trials itself and the outcome. As Ailey previously mentioned, there's already a human rights system in place, and implementing a children's rights system will cause difficulties in interactions between the two, similar to the named person scheme. My third and final point of argument is that by implementing this bill, it interferes with the devolution settlement by constraining Westminster from passing laws in Scotland. Section 6 of the bill causes concerns for the UK government in regard to the legal obligations that could be placed on government ministers in reserved areas. In Alistair Jack's letter to John Swinney, he states that the concerns is that Section 6 and 19 to 21 of the bill would be contrary to the devolution settlement, Section 28(7) of the Scotland Act 1998. He also added that although the UK government does appreciate the Scottish Government's right to legislate on this matter with its responsibilities under the devolution settlement, the UK Parliament cannot accept a law will in turn affect their ability for input into making laws for Scotland. If this bill is approved, then it can become confusing for the general public and stakeholders to understand the legislation and use it properly, with the right also being really easily open to interpretations. It leads to many number of issues to arise, such as generating an increased number of cases involving litigations, leading to increased pressure on lawyers. Another point for thought: what is in place to stop this bill from being abused? Therefore, once again, I have to highlight that this is not beneficial for children. The confusion just puts extra strain on our justice system. To summarise, before we consider making any efforts with this bill ahead, we have to consider the financial issues, recognise the disadvantages to children, and be aware of the increased pressure on lawyers, the judicial system, and the local authority agencies. Thank you.
Thank you, Libby. Okay, and we'll go straight to Kiva. Kiva, if you are ready, I will start your 5 minutes now.
Now, before I start my argument, Libby mentioned quite a few things there that I'll just give a rebuttal to. She mentioned costs. Now, lawyers aren't doing this voluntary, they are getting paid. And also there is a human rights scheme in place already. That's fine, but for years we've had to deal with orders from Westminster. Having it in the Scottish Parliament means we have a say in what is best for our children. Success doesn't happen overnight. Success doesn't come without hard work. Now, don't take my word for it. These are two famous quotes, the first by Canadian artist Petra Collins, and the second by American sports star Sandy Martinez. Now, if put that into the context of today's debate, the benefits of children for children will not happen if lawyers do not put the work in. The Scottish Parliament held the Bill's Stage 3 proceedings on the 16th of March 2021, in which Deputy First Minister John Swinney stated, amendments made to Section 4.1 are to relieve the stress and burdens on litigants and lawyers. Now, the statement UNCRC bill will create more work for lawyers and benefits for children is completely inaccurate and not to mention misleading. The work has already been reduced for lawyers and therefore is providing less work instead of more. And it begs the question, are the proposition really arguing for the best interests of lawyers? Or are they arguing that they're not motivated because they can't handle a workload which has already been reduced. Now, the idea that the bill will create more work for lawyers and benefits for children is completely ludicrous. Let's take a look at Unicef Statistics regarding the outcome and benefits of the UNCRC worldwide in the past 30 years. Some of these statistics are completely staggering. It's almost half the proportion of undernourished children since 1990. That's not enough for you. It's reduced more than 50% of deaths in children under the age of 5 since 1990. And if they are not enough, they have it's 2.6 billion more people have had cleaner drinking water today than in 1990, almost a third of the world's population. The UNCRC has ultimately transformed the lives of children and allowed them to excel. Yes, Ailey.
Would you not argue that the UNCRC can continue to transform the lives of these children, but it does not need to be in law to do this?
No, I wouldn't agree, because we as Scottish people, we've done fantastic things over the years, not just in law, but we've created so many things. So us, everyone in Scotland, we can do better for our children. There's always better. The children are a minority. We want to help them. We want to give them the best chance to excel. Now, the UNCRC has undoubtedly created so many benefits for children with the bill now being passed in Scotland. We as a society can do the same for our children, if just like other countries in the world, if not better. Without the hard work of lawyers and other acts and bills, they wouldn't be successful. Many of us wouldn't be here or in the job that we're in if it wasn't for the Equality Act per se. In conclusion, it's clear, it's completely unambiguous. The UNCRC bill will not create more work for lawyers and benefits for children. Every single person in the workplace has to be flexible and adaptable to changes. And simply, this is exactly what that is, a change, and a change that will provide a greater opportunities for all young people. When casting your vote today, please bear what I have said in mind and ask yourself this one question. What is more important to you, that lawyers have no change in their workplace, or that children's rights are upheld so they are treated fairly, their voices are heard, and they're given every opportunity to be as healthy as possible?
Thank you very much, Kiva. Okay, once again, there are particular phrases jumping out to me. That time it was less work for lawyers. It's almost as if the two teams are agreed that work for lawyers is a terrible thing, which I'm not sure is entirely on brand for Brodie's. But nevertheless, we'll see what our final two speakers have to say about that. So arguing for the proposition, we have Cameron Vargessen of Aberdeen Grammar. He's in 5th year Aberdeen Grammar. He's just sat his higher final assessments in French, history, chemistry, English and maths. Next year, he's looking to study advanced higher history and music and higher physics and RMPS for his 6th year. In his spare time, he enjoys all styles of dancing and he teaches dance classes. And against the proposition, we'll have Emma Russell, who's currently finishing 5th year at Morrison's Academy in Crieff. She's recently completed her hires in English, modern studies, chemistry, geography, and art and design. Emma's highly passionate about sport, playing both hockey and badminton, as well as taking an interest in travel and current affairs. She's excited to be starting her advanced hires in modern studies and art and design, in addition to a crash advanced hire in physical education. And on leaving school, Emma hopes to study law and travel the world. Okay, Cameron, if you are ready to go, I will start your 5 minutes now.
Thank you. Just before I start, I'd like to mention that Kima said before in her speech that the workload for lawyers would be reduced by introducing the UNCRC bill into Scottish law, which I disagree with, because I think that it would increase it, especially in the short term when you are incorporating it into the law. It would increase the work for lawyers, because incorporating a law or a bill that big into Scottish law would take a lot of work. I have a few points I would like to speak about, the first of which being the UK government challenging the bill because they're concerned about some parts of the bill possibly going past the powers of the Scottish Parliament. Yes, Kima?
You mentioned there that incorporating it wouldn't create much workload. That wasn't what I said. The amendments were made to the section 4.1 to relieve the burden on litigants and lawyers. The Act itself is not reducing it. So are you saying that the bill itself is already creating work? like more than expected?
Oh, I think because it is such a big bill, and as Libby previously mentioned that the cost would be over $2 million, that surely in that it would create more work for them to implement. Ewan?
Sorry, you've had your 3 interventions across the piece.
I will move on to my first point of argument now, that the Supreme Court is challenging the bill because they're concerned about some parts of the bill possibly going past the powers of the Scottish Parliament. The bill has been taken to the Supreme Court by the UK government, and they're asking the Supreme Court to rule on whether certain parts of the UNCRC bill go beyond what the law says the Scottish Parliament can legislate on. They argue that the bill could affect UK Parliament's power to make laws for Scotland. This makes more work for lawyers because this could, in the future, create more legal battles, as there will be more debates on whether it does go past Scottish power for legislation. The conflict which has been brought to the court has not been based on or related to the intention behind passing the bill, but is instead a technical matter related to the constitutional law and the UK Parliament's power over making laws in Scotland in a way which is not allowed under devolution. The UK government is not challenging the Scottish Parliament's right to bring in the UNCRC into Scots law. This will cause more work for lawyers, as it is likely to stay in court for quite some time, and it won't be surprising if it comes back up several times in the future because of more debates and questions over the powers that Scotland have. Moving on to my second point, which is the decision made by the Supreme Court. If the Supreme Court rules that some sections go beyond what is allowed under devolution, then it will cause a lot more work for lawyers because of legal battles that will come after that. The bill will have to have changes made to it if the Supreme Court decides that some sections go beyond, and this will mean the Scottish Parliament will have to vote in favour of it all over again with the changes included, which will include a lot of legal battles with lawyers because they will have to decide what the changes will be, and when that happens there will obviously be some changes made. Just as a summary of all of our arguments, the UNCRC bill will create more work for lawyers than it will benefits for children, because incorporating the bill specifically into Scottish law will not be all that beneficial for children, because although the whole point of it is to be child specific, the children won't understand it, which alienates them from Scots law. The alternative would be spending money to ensure children are educated on their rights, and that optional Protocol 3 is actually signed up for by Scotland, so children can complain about if they think their rights are being infringed. The £2 million predicted that will only actually cover the initial costs. It is unrealistic to think that £2 million will cover all necessary costs for the bill, and the Scottish Legal Aid Board is likely to require much more funding for the litigation to implement the bill in the future. On top of that, the 3-month period for the judicial review was introduced to avoid delays and challenges. Authorities often need to make prompt decisions of the care and education of the children. If this is delayed until the child is 18, the issue is likely to become much harder for the lawyer to correct and will require much more work for them to correct in the future. Thank you.
Okay. Cameron, thanks very much. If we have Emma ready to go. Emma, your 5 minutes start now.
Mr. Chair, ladies and gentlemen, for side proposition's motion is clearly inaccurate and misleading. Side opposition have effectively argued that the UNCRC bill would create no additional work for lawyers. However, relating back to the motion and bill itself, is it not of the best interests of everyone on this call to make the lives of children in Scotland better by paying closer and deeper attention to the vital and basic needs of our youth? Side opposition believe that this bill will not only create no more work for lawyers than already exists, but will more importantly improve the lives and safety of our children in Scotland. We believe that this is what really matters in this debate. And I shall conclude the debate by looking at the harms through main points of clash, but first some rebuttal. Side proposition have told us that by incorporating it into law would alienate children. However, on side opposition, we believe that by incorporating our laws locally and internationally, this would allow for a closer contact and understanding on resolving child rights issues as opposed to trying to tackle them on a larger scale. This would be more beneficial for not only our country's children, but also our lawyers, as these issues will become easier to tackle in the future as they're closer to home. However, on Ewan mentioned that this is when he explained that by incorporating the UNCRC into Scots law, it would be far more effective by addressing child rights, as lawyers will be able to take them personally and emotionally, therefore understanding the children better as we're from the same country, relating to our country. For example, this may force the SQA to go into reform to serve best interests for our young people. It is clear view of the Scottish Government that the SQA does not serve the best interests of our children, as they have announced that they will be reformed. This bill will force the reform to be meaningful and more than just a name change. Thus, it will create a strong benefits for children with no extra work for lawyers, as the SQA are already ongoing reform. Therefore, the lawyers will have no more work than they currently have. On to my second point. Kiva already mentioned that lawyers are not doing the work for free, so therefore the proposition are saying that we as Scotland cannot provide a better, more effective way of tackling these issues. And side opposition, we believe that by incorporating these laws, the UNCRC and Scots law would reduce the work for our lawyers, as they're already comfortable with Scots law and would be able to tackle further issues in relation to Scots law. For our lawyers, and it would reduce it. As lawyers, we will not only want to make our life for Scottish children better, but we'll also create a closer link to tackling and reducing further issues. So to reiterate my point, basically, we are saying as side opposition that it will not only create less work for lawyers, but also will have the best interests of the Scottish children at heart. So I urge you to support opposition.
Thank you very much, Emma. Okay. So you've heard from the proponents of the motion, you've heard from the opponents of the motion. If we can bring up our closing poll. So as a reminder, in our opening poll, the question, it's the same question: do you believe that the UNCRC bill will create more work for lawyers than benefits for children? We began with 20% of our audience saying yes, 60% saying no, and 20% being undecided. So if everybody in attendance can vote yes, no, or if you are still undecided, then select that option. So everyone's made their mind up one way or the other. In fact, both sides have secured movement in their direction. So the motion is still disagreed to by the majority, now 73% rather than 60%, but a higher percentage, 27% as opposed to 20%, now agree with the motion. So I think there is something in there for each side to declare a moral victory. Certainly the overall numbers are favouring the opposition, but I think it's fair to say to the proponents of the motion that you were probably going to have a tough audience for that motion in terms of the sorts of people who are going to sign up to a session like this. So I think there are congratulations to go all round there. Well done to everybody. It was very, very good debate. Everyone's timing was excellent. I was probably a little bit unfair to Ewan if Cameron had wanted to take his intervention, but certainly very well done, everybody. I didn't have to, I hardly had to intervene at all. So everyone was very well behaved, stuck to the rules and the format, very well and made your cases brilliantly. So if we can just bring up our closing slides, or possibly just slide. So I mentioned at the start that this is the last in our series of webinars on the UNCRC incorporation bill. You can see on the slide the various issues there, central government regulators and public bodies. So if you are in one of those, that may be of interest to you. And if you're particularly interested in the Supreme Court challenge and what that's about, that's the session where I went into a little bit of detail on that. That was followed by a conversation with a partner, Christine O'Neill QC, the firm chairman, who spoke to a different group of young people and to the Children and Young People's Commissioner as well. We then had sessions focused on what the bill will mean for local government and what it will mean for Scotland's third sector. So there's a whole series of information and webinars there. If you want to know more about the UNCRC bill, you can find those sessions on our YouTube channel. But otherwise, it just remains for me to say thank you for your time on behalf of Ailey Lynn of Balfron High School, Ewan Davis, George Watson's College, Libby Hunter of Douglas Academy, Kiva Gibb of Holyrood Secondary, Cameron Vargessen of Aberdeen Grammar, and Emma Russell of Morrison's Academy, and also for my own part, Charles Livingston, Trinity Academy, Edinburgh, class of 1997. Thanks very much for your time, and we hope to see you again soon. Thank you.